Doctor said it was fine, but was it really? Welcome to Law in Depth, a platform where we engage with real-life issues and put them under the microscope. I'm Philip Njoroge, and I'm here with Obafemi Fayomi. Femi?
Yes, thank you, Phil. Before we start, I would like to paint you a picture. You have issues with one of your eyes. You went to your optician and he referred you to a specialist. The specialist, of course, recommended surgery, and during the consultation process, you asked all the questions that you can think of, and then you have the surgery. And after the surgery, you realize you were blind in the wrong eye.
Wrong eye?
Yes, Phil. Not the one they operated on, the other healthy eye. You went blind.
And so what did the surgeon say about that?
Well, the surgeon said, well, I acted in line with accepted medical practice, and my colleague will have done the same.
So saying that I've acted in line with accepted medical practice, is that a defense?
That's exactly the question. And the answer, in Australia at least, might really surprise you.
Okay, so before we dive in, kindly note that this is not legal advice, and you should seek the services of a lawyer if you're having issues. Back to you, Femi.
Okay. And as you may have guessed, yes, thank you. As you may have guessed, what we are discussing today is medical negligence and revisiting the legal test that has shaped how courts decide whether your doctor did the wrong thing or did something wrong. We are talking about Bolam test, which might be new to some and might not be to some people. Bolam test essentially was taken from an English case, and it sort of tell us where power sits with the patient or with the profession.
So, to all our viewers and our listeners, before you scroll down or move on to something else, pause for 1 second and ask yourself, will I ever go to a GP or specialist and get a medical procedure done? And if you're worried about being let down after a medical procedure or medical treatment, then this episode is for you, because this is about your rights.
You're right. This is about what you are entitled to be told before you agree to something done on your body. And it's about what happens when things go wrong.
That's right. So let's get into it. So what is this Bolam test, Femi?
Yes, thank you. So first, the Bolam test comes from a 1957 English case. We're talking about a man called Bolam versus Friar Hospital Management in 1957. So the fact of the case was that the patient, who in this case was Bolam, received an electroconvulsive therapy, and while he was receiving that treatment, he was not given any muscle relaxant or any form of restraint. And for some people familiar with that surgery, it's a sort of surgery that is going to cause you to jerk a lot. And during the procedure, as a result of not administering any muscle relaxant or any physical restraint, he fractured both his hips, and yeah, it was really bad for him.
That's horrific, Femi. Yeah.
It is very horrific.
Mm.
The English court said a doctor is not negligent if they acted in a way accepted by a reasonable body of medical opinion. Even if other doctors disagree, it doesn't come under negligence. And even if there's an alternative safer approach, that will also be irrelevant. So that's where Bolam test originated from, and that's what really defined what Bolam test is.
So let me get this straight. If enough doctors in the field that you're practicing in would have done the same thing, you're off the hook. That's pretty much what Bolam is about.
Because the profession sort of regulates itself, and the tension exactly is what Australian courts eventually had to grapple with. Yeah.
That sounds convenient for those doctors who are conducting such
Yeah, it is.
procedures. Yeah.
Well, yeah. Yeah, but in 1992, the High Court of Australia drew a line in the sand and said, when it comes to what your doctor tells you, the Bolam test does not apply in Australia.
Right. So they didn't adopt the Bolam test. And so when it comes to what your doctor tells you, the applicable case is Rogers versus Whitaker. And I think the facts in this case are a bit astonishing.
Are you honest? So just to quickly run through the fact of the case, the Whitaker is the one. He's been nearly blind in the right eye since childhood. She found a surgeon, Dr. Christopher Rogers, and who said he could improve the vision in that eye. She asked many questions, and the surgery was performed. But the doctor never told her that there's a risk called sympathetic ophthalmia, and what that means is that where trauma to one eye is happening, it could affect the other eye. So the fact that he went for the surgery, there's a potential of that sympathetic ophthalmia where the other eye will pick up the problem of the second eye.
So she didn't she was not informed about the risk of that happening. And so what was the risk of that happening? That sympathetic ophthalmia?
Yes, the chances of that risk happening is 1 in 14,000. So
a
if
very,
there's a
very
14,000
small,
surgery done,
yeah,
one minute, very, very tiny, but it happens.
yeah.
She became virtually blind in both eyes.
And let me guess. So the surgeon's defense was, I followed standard medical practice. Most surgeons wouldn't have mentioned a 1 in 14,000 risk. Is that what he said?
That's correct.
Ah,
And the High Court said, yes, that's correct. That's correct. And the High Court said, that is not the right test. The test for disclosure in Australia is what your peers will have told the patient. The test is what a reasonable patient in that position will want to know.
right. So the court thus shifted power from the doctor's profession to the patient's perspective.
And
Yeah.
that became the cornerstone of informed consent law in Australia.
Right. So now back to Bolam. So the Bolam test, or the principles in that case, haven't entirely been thrown out in Australia for treatment decisions and how surgery is actually performed. So courts still consider the professional peer opinion, and we have this authority of Naxakis and Western General Hospital. It's a 1999 decision. And in this decision, the High Court confirmed that the standard of care in clinical decision making is influenced by what competent medical peers would have done. But it clarified that the court has the final power to decide, and not the profession.
The profession's opinion is an evidence. It is not the verdict. So
Right.
the professional opinion can influence the verdict in terms of evidence, but it's not the verdict
itself. And so the legislature in Australia, and specifically here in UA, ended up changing the legislation and sort of reintroducing Bolam somehow. And specifically, I'll take you through Section 5PP, which states that a professional does not breach their duty if they acted in a way that's widely accepted by a significant number of respected practitioners. However, subsection 3 says that a court can still find negligence if that accepted practice is irrational. So the profession can't just close ranks and protect each other indefinitely.
No, they cannot. They cannot just close ranks and
I want to push back a bit and talk about informed consent and material risks. There's a reasonable argument that we actually need both the Bolam type protection for doctors. I want to play doctor's advocate a little bit and say that medicine is not an exact science. If every imperfect outcome became a lawsuit, we'd get what we call defensive medicine. So unnecessary tests, paralyzed clinicians, and a broken system. So we wouldn't want something like that, would we, Femi?
Yes. Yes, I do hear that. And
Yeah.
I don't dismiss that entirely, but it conflates two completely different things. Protecting doctors from being sued for difficult clinical calls, reasonable, and using that protection to justify not telling a patient about risks to their body. No, I don't think that's right. That's paternalism dressed up as professional standard. That's the way I'll put it. My response to that is that the courts draws the line. And that's, again, going back to Rogers versus Whitaker's point, where Mrs. Whitaker was not suing because the surgery failed. She was suing because she was never given the chance to decide whether to take the risk or not. And that decision belongs to her exclusively.
The test in Bolam would be fine for how a doctor swings the scalpel, but not for whether the doctor told you what could go wrong in a surgery or in a medical procedure. Is that?
Well, I think of it like a financial advisor. They can use professional judgment on how to invest. They cannot decide for you whether to invest in high risk assets without telling you about the risk. The decision is yours. Medicine is the same. Informed consent is not a formality. It's not a signature on a piece of paper, really. It is the transfer of power back to the person whose body's on the table. Because eventually they are the one who's going to suffer this consequence or lack of consequence thereof. So it's giving back the power to the patient whose body is actually on the table, literally.
Right. So a lot of people will sign these consent forms. We've had this argument before with Femi, where we ask ourselves, should the consent forms be a stack about this thick, informing them of every possible risk of what could go wrong in a surgery? And the other thing is, most people, because we won't take the time to read some of these consent forms, and they would assume that those forms would just protect the doctor anyways if they didn't explain the material risks properly.
So a signed form is an evidence. It's not a shield.
Yes.
If you weren't genuinely informed of a material risk, that form would not save the doctor. I'm not the one that said so. The High Court did.
Right.
So it's an evidence that there was a discussion around informed consent or material risk. But if you weren't genuinely informed of that material risk, the form would not save the doctor, according to the High Court.
Right. So what would our listeners or our viewers, if they were trying to get the gist of what we've just discussion?
Okay. Yes, for our viewers and listeners at home right now, few practical things. Before any procedure, ask directly, what are the risks? And what if I don't have it? What are the alternatives? You are legally entitled to that information. It's not a courtesy. It is your right. Secondly, if something goes wrong, the question is not just, was the surgery performed badly? Also ask, was I properly warned? Those are two separate potential claims. And thirdly, time limit applies in Western Australia, for example. It's 3 years from when you knew or should have known about the harm. So don't sit too long on it because of the time limit. And mind you, from when you knew or when you should have known, that's also very important to pay attention to. And fourthly, do not rely on hospital own complaint process to protect your legal right. I'm not saying the hospital are not doing their best, but get an independent legal advice. Many personal injury lawyers offer free initial consultations around issues like this. So get an independent legal advice and they might be able to sort of guide you through what you need to do.
So I just wanted to remind the viewers and listeners again, this is just general information and it's not a legal advice. We're just giving you the framework that's general to any situation that somebody could be going through. And so for your own specific situation, you need somebody who's actually looking at the actual facts and they will tell you how to proceed and go forwards. So before we go, Femi, I want to come back to Mrs. Whitaker. So she asked the questions, she did everything right, and she still wasn't told.
Yes. And the High Court looked at that and said, the doctor's profession cannot decide what you need to know about your own body. You decide. So it's giving back the power to the patient because the doctor cannot decide to say, oh, this is what you should know about your own body. You should be the one that's making the final call.
Right. So 30 years on, and you being somebody who is bang in the middle of it all, on the front lines in the medical profession, do you think that lesson has landed in Australian medical culture?
So in terms of the law, yes, I believe that's landed. But in terms of culture, well, that's another symposium discussion.
So, Femi, would you like to round it up for us?
Yes. So thank you.
Yeah.
That's the question we tried to answer today. Hopefully we've come to answer some of your questions and we've really informed you about what you need to know about your rights. So if you love this episode, please share this episode. Leave us a review. Please do. Tell us what you think of what you think should have been talked about. And we'll quite appreciate it. Thank you. See you next week on Law in Depth. Stay informed and stay sharp. Bye.